Finally, I just want to state, before I turn it over to Chief Rossler, that we are open to discussion on all of the recommendations, to include and to hopefully reduce some tension today, independent review. We are not afraid of scrutiny. Unique police powers, I've spoken about these in the past, Chief Rossler can speak to them, and I think of the power of arrest, I think of the power to use deadly force, I think of the power of discretion are granted to police, by the public, and that trust has to be maintained. I did recommend an independent auditor review model in 2011, so again, I can sit here and say that I'm not opposed to, independent review, and that had the option then of adding one additional layers to include a community component as well. There is no one review model. It's whatever we want as a community. And all I've ever asked, and I'll say it again, is that any model that we choose, if we decide to choose one, has to be fair to all. I am biased, obviously, toward the police department. Police officers and many others, sheriff's deputies, have hard decisions to make in many cases. Whatever we decide to do simply has to be fair. It has to be comprehensive. It has to be objective, and findings have to be balanced, on the facts and circumstances, on law, and on the evidence that's presented. And when I say fair, it has to be fair to the community and others involved as well. But we have to have a fair process, whatever we decide to do, and to follow due process. So again, we are open to discussion on all of the recommendations. We may not agree on every detail, but certainly if in principle, we agree on many of these, if not all. And I look forward to working further with the commission members, the police department, the sheriff's office, CSB, and many others going forward. So again, with that, I'd like to turn it over to Chief Rossler.
Recommendation number 16, it is suggested that we shorten the current 6 to 20 month time frame to internally investigate and close officer-involved shootings. And the $64 question is how? And that directly involves the Commonwealth Attorney trying to wrap our hands around that delay, particularly in the Gear case, is a very difficult subject. But we ought to be talking about how could we have done things differently, and that involves Commonwealth Attorney, the police, and us. So you suggested that we do it, but the how is where the rubber's going to hit the road. Did you talk about that, and as your subcommittee, as to how perhaps we should be trying to close that gap?
We didn't talk specifics on how. We definitely think that the amount of time that it takes currently is too long. But the how we assumed would come out when the report and the recommendations were adopted by the board and implemented, because the how has everything to do with not only communications, but the other related areas such as budget, personnel, etc.
An impact on an investigation that was ongoing, which had a direct bearing on our not releasing the information. Thank you.
Okay. Dave.
Yeah, very briefly, just on Supervisor Fry's question and Supervisor Highland's question, and valid questions that we have had as well. And again, recognizing that the intent of the committee is one thing, but part of back to that process, part of it as I work through these recommendations with others, the Commonwealth Attorney's Office, the County Attorney's Office are key on both of those kinds of questions you had, because we do have to work through One, when do we, if we can release information, so we do not jeopardize the rights of anyone, including police officers, or jeopardize the prosecution in any way. And then, the other part is when we're allowed to interview the involved officer in some cases, both for protection of their rights, but then also we've had direction from the county attorney's office and the Commonwealth attorney's office in particular in the past not to interview the involved officer until the prosecutorial decision has been made in some cases, and usually when the prosecution is done. So we have to keep working through that timing issue with the Commonwealth attorney as well.
John?
Well, yeah, I think this is going to be one of those areas that we need we're going to need to have a meeting or more on just this question. One thing I hope we all recognize is we cannot have a policy anymore that says we simply do nothing until the Commonwealth attorney tells us to do something that we can, because that obviously takes too long. And without the communication of the why, Mr. Commonwealth attorney, are you telling us not to? When is your, what is your time frame? I mean, there's no communication, and we cannot hold up the management of our police department for months or years just because some independent, constitutional officer that doesn't work for us, he's doing whatever and we don't know. So we're going to need some recommendations back, I think, from Mr. Rohr, from the chief and others, that we have to have a process that allows our internal review to start soon. And, let's invite the Commonwealth attorney to come in front of us and talk to us about what he thinks. But we can't do nothing for months and months and months. That should be obvious.
Pat?
I'm sorry to maybe disagree a little bit, but I don't think the Commonwealth attorney stopped us from doing anything. I mean, that's the real issue here is our on advice of our counsel, we didn't disclose stuff. I see a head nod over there in agreement. I mean, there are certain things that we certainly could have told the story, and I understand it was all drafted and ready to go, and we were told not to disclose. So we can change that. That's in our control. Now, I think we have another problem, and Mike is entirely right. We need to have that communication with the Commonwealth attorney, because the incident that kicked this off clearly wasn't handled the way it should have been handled. But I don't want to sit here and let the audience think that there wasn't a decision that was made by this board, because there was a lot of discussion about it, a lot of disagreement about it, but it was this board that made the decision not to disclose or to allow the chief not to disclose, so, anyway, this isn't all the Commonwealth attorney is all I'm saying. A lot of that falls internally on our county attorney and the decisions that we made.
And if I may, I appreciate that point. I wasn't just talking about the one case, though. I'm just talking about back to the process of how we work through these. I do, as I say, I do have to engage them. We have wanted to find a way to work around. We think it takes too long. But we do have to have that dialogue. Certainly in the one case, there are different issues, but overall, we have been asked, directed not to interview officers in some cases until, you know.
But I'm talking
later.
more the disclosure side of it, disclosing what happened, including the discrepancies where they are. That clearly doesn't wait for the Commonwealth attorney. It shouldn't wait for the Commonwealth attorney.
Although our policy, the county's policy, up until now has been not to release the name of the officer until there has been a decision to either prosecute or not prosecute, and then release the name, so that there's full disclosure, you know, to the public. Obviously, that didn't go well in this particular case, because for a number of different reasons, there was not a decision made at the level of the Commonwealth attorney as to whether or not to prosecute or not, and so there was but let's not try to get into who struck John as far as this particular case goes. But up until now, we have had a policy that says we release the name of the officer when there has been a decision whether he or she is going to be indicted or not. And that just didn't happen for a very, very long time in this case, which turned out to be nuts.
It wasn't just the name of the officer, it was the facts and circumstances surrounding the thing, because we had several discussions on that, but you're right, we don't need to belabor this, but it wasn't just the name of the officer that wasn't disclosed, we just didn't give a statement of even what happened and where the discrepancies were, which is what the public was really looking for. And it's our policy, it's not the police department's policy, because he works for us, it's our policy.
Chief.
In closing, Murray and the subcommittee, thank you for that report. And I can let's look back to January 5th of this year, and we know the policy did not work. And if we abided by that policy, we still would not have released anything today. And on January 5th, we made the decision to release the name and the information, and it was way too late in the game. We know that. But by practice, we have changed the policy moving forward, and I pray that we don't have another officer involved shooting, but the reality of the profession is what it is. But I recognize what the subcommittee has recommended, and just to expand on Mr. Fry's question, in the PERF recommendations, for example, for the precision immobilization technique, there's a recommendation by PERF that you do away with that technique. Obviously, law will allow that certain levels of use of force. So when we use that as an example, yes, the law allows it, but we need to go to the higher level, in my opinion, is tighten that policy that you can only use it for these set of circumstances. Shooting at or from moving vehicles, the PERF recommendation is to tighten that policy, and that's based upon the principles just articulated. Just because the law says you can, is it still the correct thing to do? And obviously our policy right now instructs officers shall attempt to move out of the way of a moving vehicle. So that puts it at a higher restriction rather than put yourself in a situation where you can legally use force. There's other ways that we could train you to make a decision. It might be right, but was it the right thing to do?
we recommend explicit policy against officers shooting at or from a moving vehicle. If I could make one recommendation, to your department or to the country, I would say, do not allow officers to shoot at moving vehicles under almost any circumstances, except when there's, like, say, someone with a gun in the car. This policy was implemented in the New York City Police Department in 1972, and it resulted in a dramatic drop. Not a big problem here in Fairfax County, but it's one of the things that you can tighten up, is you're not allowing it. And, the whole issue of officer safety, to be honest, almost no cases in the country where implementing this policy results in problems with officer safety. If anything, it results in officers not getting hurt, because standing in front of a moving car is only going to get you hurt, and it's not going to stop the person in the car. So we're very strong on that. We've recommended that in everywhere we've gone.